I'm sure that most of you are familiar with the text of the Second Amendment, which protects the right of the people to keep and bear arms. That seems to me that we, the people, have the right not only to keep arms, which means to own guns and to have them in our home, for example, for self-defense, but it also means we have the right to bear arms, which means that we have the right to carry guns outside of our homes for self-defense, among other things. So how is it, gang, that the anti-gunners say that you and I do not have a right to carry a gun? Doesn't the plain language of the Second Amendment, which protects the right to bear arms, already answer this question? Spoiler alert, yes, of course it does. And the debate over the right to carry guns outside the home should be just that simple. Hey folks, I'm Mark and welcome to the Four Boxes Diner. The United States Supreme Court has before it today the most important Second Amendment case in over a decade. Now that's the New York State Rifle and Pistol Association versus Bruen case. And the Bruen case raises the question of whether the Second Amendment protects a right to carry, that is to bear a firearm outside the home for self-defense. Now, the anti-gunners argue that there is no right to carry guns outside the home. They say that the government can ban you and me from carrying a firearm. But if you look at the plain text of the Second Amendment, if you just look at it alone, right, the Second Amendment's text alone completely destroys that argument. Let's start with who has the right. That would be the people. The founders who wrote the Constitution in the Second Amendment stated very clearly, the right of the people to keep and bear arms shall not be infringed. Now these rights are just that. They are our rights. So no matter how many times the anti-gunners say that the Second Amendment has nothing to do with individual rights and somehow is all about the militia or the National Guard or the military or whatnot, the reality is that the U.S. Supreme Court ruled explicitly in the District of Columbia versus Heller case in 2008 that the Second Amendment, and I'm going to quote the Supreme Court because it's such great language, quote, "The Second Amendment protects an individual right to possess a firearm unconnected with the service in a militia and to use that arm for traditionally lawful purposes such as self-defense." That's not me, that's the United States Supreme Court. The conclusion that the Second Amendment protects an individual right is really a no-brainer to me. And all you really need to do is look at where the Second Amendment appears. It appears in the Bill of Rights. Individuals have rights. And if you look at our Bill of Rights attached to the Constitution, it lays out our constitutionally protected individual rights that the government cannot infringe upon. After all, the Second Amendment says that the people shall have the right to keep and to bear arms. Now, the Fourth Amendment, the Ninth Amendment, the 10th Amendment, all a part of the Bill of Rights, also refer to the people. And the Supreme Court has made it clear again and again that the term the people refers to individuals and not some collective. So if the founders intended that the Second Amendment somehow grant powers to state governments to form militias or to build a military or create a National Guard, the founders sure put it in a really funny place in a Bill of Rights guaranteeing individual rights to us, the people. The anti-gunners commonly claim that the Second Amendment supporters ignore the amendment's opening clause. That's the clause that reads, "A well-regulated militia being necessary to the security of a free state." But the reality is, we don't ignore that opening clause, nor do we need to. You see, Second Amendment supporters understand that the meaning of the phrase well-regulated militia, we understand what it means at the time of the founding. And we simply reject the efforts of the anti-gunner community to, redefine that phrase based on modern language use. They're trying to redefine well-regulated militia based on what people use the word well-regulated to mean today, not at the time of the founding, which is how you interpret the Constitution. So let's break the clause down just a little bit. The phrase well-regulated in the Second Amendment has nothing whatsoever to do with government regulation as we think of that today. The words actually refer to men being trained and proficient with firearms. Militia is another word that appears in the Second Amendment that the gun grabbers often like to try to make kind of hay with, right? They point to the word militia and they say something like, see, the Second Amendment says that the right to bear arms exists only in the context of serving in the militia or the military or the National Guard or something like that. So what we're really talking about with the Second Amendment is some state-sanctioned military service, you know, something like the National Guard or what they would handle today, the National Guard or something like that. Anyway, that's really what you will hear the anti-gunners say in various op-eds or letters to the editor, maybe you read in your local paper. Of course, that's all wrong and simply absurd. And to understand why, you really don't need to wade through all of these court decisions and legal analysis on the subject. I mean, I've done that, so you know you don't have to, right? I've borne the burden of that so you can dodge that headache yourself. Here are the essential points I'd like you to know about. First, the framers of the Constitution did not understand the word militia to mean only state-sanctioned military units. Many of our founding fathers spoke of the militia being the entire adult male population. After all, the Minutemen who stood up to the British at Lexington and Concord in 1775 at the start of the Revolution were really a group of townsmen, right? That's right, they were townsfolks. Second, as the late Justice Antonin Scalia explained in the Supreme Court's Heller decision, which we talk a lot about, the phrase well-regulated militia is part of what's called a prefatory clause, which was common at the time the Second Amendment was drafted. Now, prefatory clause does not restrict the meaning of the main or the significance of the operative clause. All it does is to explain kind of the purpose of the operative clause. And in Scalia's words, and I think it's better to always use, Scalia's words or the Supreme Court's words, although I think my words are pretty good, but I think, they're much better and much more important to the Second Amendment debate. Here's what Scalia wrote in the Heller decision. He said, quote, the Second Amendment's prefatory clause announces the purpose for which the right was codified, to prevent the elimination of the militia. The prefatory clause does not suggest that preserving the militia was the only reason Americans valued the ancient right. Most undoubtedly thought it was even more important for self-defense and hunting. So again, Scalia nails it as he usually did when he was alive. Now, recognizing this history of the Second Amendment, the United States Department of Justice, back in the year 2004, issued a 103-page report. This was even before the Heller decision. They issued a 103-page report with something like 440 or 430 footnotes, believe it or not, concluding that the Second Amendment secures an individual right to keep and bear arms, and that a right of the individual is generally not a right of the states or some sort of right restricted to individuals serving in militias or the military. In fact, I'm going to put a link to that Department of Justice report down below in the comments on this video if you want to check it out. And also put some other links down there, which I usually do for backup sources in case you want to do some more reading on some of the things I talk about. I just generally do that, even though I don't necessarily always mention in the videos like I just did right here. Okay. Let's have a little thought experiment. Let's take the anti-gunners' arguments and apply them to the First Amendment's free speech clause. The First Amendment could have had a prefatory clause as well, just like the Second Amendment does, right? Somebody could have written something like, a well-educated public being necessary to a free republic. Well, that's an announcement of the purpose of the First Amendment, let's say, but it certainly would not limit the rights that followed as to free speech, and free press, and other things like that. So why should the analysis and conclusion be any different given the prefatory clause of the Second Amendment? The answer is, it shouldn't. Now let's turn to the phrase to bear, as in to bear arms. The anti-gunners' argument that to bear arms or to bear means to serve in the militia also fails for several other reasons, okay? Let's just take a look at the state constitutions. Again, the Second Amendment is part of the federal constitution, but there were state constitutions adopted at around the same time for individual states that set up the state governments and set forth the rights of the individuals living in those states. So let's take a look at some of these state constitutions adopted at around the same time as the Second Amendment and see how those state constitutions use the phrase or the language to bear arms. Well, those state constitutions also use the language in a way that plainly refers to both serving in the military and carrying private guns for self-defense. Now, the rights that those state constitutions recognize for their citizens provide a very important context for the Second Amendment as well. The fact that the founding generation, right, the people that were alive at the time of the Second Amendment's ratification in 1791, right, the fact that that founding generation used the phrase bear arms to include the right of self-defense, private self-defense, shows that the phrase cannot be limited to only serving in the militia or a National Guard or some other military unit. Another reason why the phrase bear arms cannot refer to militia service alone is that the Second Amendment doesn't just say you have a right to bear arms. It says you have a right to keep and to bear arms both. Separate, related rights, but separate two rights in the Second Amendment, not just one. You see, nobody really argues, even in the anti-gunner community, that the right to keep arms refers to serving in the militia. It obviously means that you have a right to keep arms or to have arms in the home or privately for self-defense. Now, nor is there any evidence, of course, that the full phrase, the right to keep and bear arms, refers to just militia service. So how do the anti-gunners try to overcome this obstacle? Well, they argue that the phrase bear arms by itself is kind of a technical legal speak for lawyers, apparently, for serving in the militia. So essentially what many in the anti-gun community are saying is that the verb to keep, right, to have, to keep, should be understood as meaning to keep guns in the home for your private self-defense of you and your family, which obviously is an ordinary meaning of keep arms, right? But what's weird, what the anti-gunners say, and this is what's, you gotta like blow your mind up when you think about this other argument. They say, yeah, to keep involves private self-defense in your home for guns, but that the verb bear, to bear, in the same exact sentence of the Second Amendment, right? To keep and to bear. In the exact same sentence, they say the verb bear somehow should have a secret, technical, legal speak meaning of serving in the militia. I mean, how absurd is this kind of an argumentation that half the sentence refers to guns in the home with to keep, but the other verb, to bear, somehow means technical militia. Obviously, this is absurd. It is entirely confusing and far more confusing than, let's say, the I don't know, who's on first gag. It's an absurd argument, but it's one that the anti-gunners are making before the Supreme Court now and in the past. Let's get back to the basics here. The fact that the Second Amendment protects both the right to keep and to bear arms means that the right to bear arms must apply outside of the home. If bear arms meant only to carry arms inside your home, then it would mean the exact same thing as to keep arms, which means to have guns in the home. But the fact is that the Second Amendment separately provides for both of these rights, to keep arms and to bear arms. And the fact that it has both of these means that these verbs have to have two different and separate meanings. If the Founding Fathers meant to provide only a right to have guns in the home, then they would have drafted the Second Amendment to say simply that you have a right to keep arms. Period. Full stop. But that's not what the Founders did. When the Founders wanted to say something, they knew how to write it. For example, when the Founders wanted to limit the exercise of a right in the Bill of Rights to a specific place, right? Like your house. They actually wrote it into the Bill of Rights. What a novel concept. Let's take a look at the Third Amendment. You may remember the Third Amendment, or you probably don't because it doesn't come up really at all. And that is that the Third Amendment in the Bill of Rights prohibits quartering troops in any house. That's what it says, in any house without the owner's consent. So again, the Third Amendment is limited to a house, and it says in any house. It actually says it, okay? The Second Amendment doesn't say that. And if the Founding Fathers meant to provide only a right to serve in the militia, they would have said just that, but that's not what they said. So let's wrap up. Today we've discussed how the actual text of the Second Amendment answers the question whether we have a right to carry guns outside of the home. The Second Amendment protects both the right to keep arms and the right to bear them. And to bear arms means simply to carry them. It's really just that simple. Now, the anti-gunners in the Bruin case are going to attempt to persuade the Supreme Court that the Second Amendment, as it's drafted, does not mean what it plainly says. And that they're going to argue that the Founding Fathers, who risked their lives and livelihoods and fortunes in the war for our independence, intended that we, as a free people, would have the constitutional right to protect and defend ourselves, our families, and to protect these newly won freedoms only inside our homes? Absurd, right? In fact, this assertion by the anti-gunners is really laughable on its face, and is not supported by our history at the time that the Second Amendment was drafted or ratified, or supported by the actual language of the Second Amendment itself. Make no mistake, the language of the Second Amendment was subject to intense discussion, debate, analysis when it was drafted, just like the rest of the Constitution and the rest of the Bill of Rights. Each of these words set forth in the Second Amendment were carefully chosen by our Founding Fathers. And they were not intended to have some sort of false and secret meaning of the sorts that we see many in the anti-gun community asserting some 200 years after the founding of our nation. Thanks for joining me here at the Four Boxes Diner, where we serve hot, fresh Second Amendment news and analysis. So if you enjoyed what you heard, please subscribe and spread the word, and we'll see you next time here at the Four Boxes Diner.
Orders up. Table 2A.